The Supreme Court's decision did not grant custody to the adoptive couple from South Carolina, but it did focus on continued custody, something the court said Dustin Brown did not have when he invoked the Indian Child Welfare Act. The head of one Tulsa adoption agency says the ruling does provide greater clarity on the law. Attorney Mike Nomura heads Heritage Family Services. It's a nonprofit licensed adoption agency in Tulsa that provides adoption services throughout the state. He, like members of Cherokee Nation, was stunned by the High Court's ruling Tuesday.
At least the traditional interpretation of the Indian Child Welfare Act by state courts here in Oklahoma and in other states seem to favor their position. But so I was initially surprised by the Supreme Court ruling.
What the ruling does do, he says, is provide greater clarity about how custody is now viewed within the Indian Child Welfare Act. The federal law keeps Indian children from being taken from their homes and placed with non-Indian adoptive parents. In this case, he says, it implies that Veronica was not taken from an Indian family because biological father Dustin Brown never had custody, nor did he have continued custody.
I think most adoption agencies and adoption attorneys will greet this as some clarification. However, I think the tribes are going to be vastly disappointed by this.
Regardless of the ruling, Nomura says adoption agencies in Oklahoma will continue to work closely with both state and federal Indian child welfare laws to ensure that a child's Indian heritage is preserved.
Adoption agencies here in Oklahoma are going to continue to have to work cooperatively with the tribes and seek to find an appropriate placement.
In a conference call this afternoon, the lead attorney for Cherokee Nation reiterated the fact that Dustin Brown never gave up his parental rights. She called the Indian Child Welfare Act the gold standard. In Tahlequah, Max Resnik, 2 News works for you.